So you have a lot of interesting issues which relate very much to some of the things that are discussed in the practice in universal ethics in regards to justice, objectivity, and also just the general parameters of Noahide law. So first of all, there is a dispute whether or not, and we've discussed this on previous occasions too, whether or not Jewish procedural law, or I should really say biblical and Torah procedural court law applies to Noahide law or not. According to the baseline approach, the answer is no. I may have mentioned this before. According to the baseline, no, that's something that is okay for the nations to develop on their own. So even though the nations are not to create their own religion, but if it's the proper process and procedure, the methods how to go about enforcing Noahide law and adjudicating, meaning deciding who's guilty and how people should be compensated for civil wrongs in Noahide law, that is fine for the Noahide communities on their own to develop. Okay, so that's very interesting and worth noting. With that comes another interesting rule, which is that even under the approach that Jewish civil law, Talmudic civil law, in other words, scriptural, and the oral law in regards to civil procedure, court procedure applies to the nations, but rules that are divine decree, which means they're not rational and they're not, they are deemed to be exclusively for Israel, don't apply. So then it gives examples here in the book. What we're referring to is how many judges are needed and rules about what kind of witnesses are required, and also the pre-punishment or the pre-crime warning is not required. So those are things that, in other words, a more rational approach, a more flexible, rational approach to adjudication will be permitted, even though other Jewish law will apply. So in other words, you have this interesting thing where a lot of the more rational civil law that fills the Talmudic volumes, that will apply. Laws that have to do with whether assumptions about someone's telling the truth. There's a lot of interesting oral law and Talmudic law. And according to the Nachmanides approach, I'm not mistaken here, those will apply. However, and so this is, you can see this on page 249, discusses these two views of how we approach. It's called the positive legislative rules. In other words, rules that are, how would I say, crafted by the society themselves. That's what we mean by positive. They're created, they're not ordained from on high, but created. The difference opinion about that, whether that is something that's done or not. Now, there's another thing, very interesting point that's brought up here, and that is on page 252, whether justice as active or as abstract. Which what he means by that is justice something individuals are empowered to carry out on their own? Or is it something that is the law that's to be studied and then carried out by judges alone or by the government? And the example is given somewhere here about the famous story of Shechem, Jacob's sons, and the city of Shechem. There's an approach that the justification for Shimon and Levi, Simon and Levi's killing of the men of Shechem is because they violated Noahide law. What's that law? This law of establishing courts, meaning what? The king's son violated the law of theft by stealing Dinah and holding her against her will. and therefore they were supposed to take action to criminalize that, and they failed to do so, and therefore they're punishable by death. So that's one approach. But what we can see from that approach is that they have actually an obligation, even though they're not government. The individual had an obligation to enforce Noahide law. So that's a very heavy responsibility. So that's one approach. Another approach is that no, we can't expect in that story, they weren't punished because of that, but there were other reasons for their killing or execution. I mean, the truth is, when I read this story, I think that when you first read it, it doesn't appear to be a story of judicial action on the hands of the brothers. It seems more to be a part of the rescue. What I mean by that is that, well, first of all, I think if you look at a lot of biblical stories, you see that, including this week's story, in this week's reading, that the Torah does believe in a certain form of collective punishment. And we have to understand why. We have to think about it objectively, why that would be the case. But I think that there's two ways of judging that the Torah doesn't seem to believe strictly in an individualistic form of judgment. In other words, we all don't only look at you personally, but you will be held responsible for the acts of your nation unless you disconnect from your nation. So in other words, if your government acts in a certain way or makes war, if a certain, again, for example, the story of Midian. So when the Midianites sent their women basically in a form of war, of attack, in order to instigate a plague, and that was the purpose of what they were doing. They knew that their purpose was to bring down God's wrath on the Jewish people through getting them to sin. So it was an open attack. So under those circumstances, it's seen as the nation is taking action, not just certain people, but it's viewed as the nation launched an attack, and they were attacked similarly as a nation. All the kings were involved, right? Even on the highest level of government, where the princess was cohabitating with the prince of the tribe of Simon for the purpose of getting him to commit idolatry, and this was happening en masse. So the point is that it was something being done by the nation, by cross section, even you could say, and that they drafted women to be involved in this, and therefore it was an attack by the nation itself. It's interesting that Rashi, I believe it's this week, discusses why was the attack against Midian and not against Moab, which was also involved. So why was that? In fact, if you look, I believe that the verses in the week before say that the children of Israel, that men were socializing and they were fraternizing with the daughters of Moab, not Midian. The only thing is that the particular princess was the princess of Midian that was involved with Zimri, prince of tribe of Shimon or Simon. So it's interesting. On the one hand, it seems like the majority of women were from Moab, yet the attack is against Midian. So why is that? That's bizarre. So Rashi gives two explanations. One is, he says the reason is because their hostility was more abhorrent because they have no business over here. He says, why is Midian getting involved? Moab had some justification why they did this, because they were close and they were could have been harassed, or they had a legitimate fear of being harassed by the movements of the Israelites in the desert. Well, Midian was far away and had no real concern of there being any type of threat or harassment from the children of Israel and their movements. That's the first thing Rashi says. Secondly, he says is that it has to do with the fact that Ruth is going to come out of them and certain important Jewish figures, and therefore, so God decreed that they shouldn't be touched on this occasion. So in other words, it is really, in terms of a rational approach, they should have been, but because of future reasons and merits, so God didn't decree that they should be attacked in this occasion. So, but anyway, the point is really, that's a little bit of, I digressed a bit, but the point is that there seems to be, on occasion, an approach which has nothing to do with individual justice, but has to do with the collective justice. In other words, that there's a justice on a nation, and if you're a member, you can get caught up in its punishment. I think that's the right way to look at war as well. You know, although it can be argued that many innocents may die in a war, but and from a certain perspective, it seems so unjust and so wrong. But from another perspective, the idea is that the nation is at war, and generally speaking, that is the case. Is that in a war, for example, everyone is mobilized in most, to assist, whether it's to provide food, to provide money and taxes, to provide shelter for the soldiers, to provide, the actual people involved in the fighting, obviously. So the whole nation is involved, and the whole nation, it's a war between nations. And from that perspective, that the fact that the attack would be an attack even on what's otherwise be deemed civilians, is from a certain perspective understandable, although still difficult for us to wrap our heads around. So I guess what I'm arguing is in the case of Shimon and Levi, of Simon and Levi, was similarly it was more of an attack than the meting out of some kind of justice on them as individuals. I'd also like to add something else, that I think that the reason for the attack may have been just as a preemptive act of protection. In other words, it was something necessary in order to effectively save their sister. Because if they didn't if they didn't execute the men, then what would happen? Even if first of all, in his attempt to save his sister, they could be mobilized in an attack against them. So, I think that's really the simple reading. The simple reading is this was a preemptive attack on them in order to prevent them from defending their king and preventing Dinah from being saved. Now, Ross is shaking his head, so I'd like to know why.
I'm just thinking. It's a movement for thinking. That's all.
It looks more like Rabbi Weissman doesn't know what he's talking about. But
No. You're fine.
Okay. So, here we have, now it actually is brought here, and I have to look into further that those commentaries that say that the occupants, the residents or citizens of Shechem were killed by Shimon and Levi, not due to their own personal crimes, have other explanations. I think this is the simple explanation. The simple explanation is that they were seen as a rodef. They're like pursuers. In other words, the assumption has to be made that they'll come to their king and their prince's aid. That's a normal way that in those days that kingdoms behaved, that the kings represented the people. They were seen as an embodiment of the entire nation. And if they were attacked, then their people would stand up and assist. And in order to preempt them from doing so, they killed all the males who in those days were considered the arms-bearing members of the society, while women were not. Again, it's a different world in which sometimes you may read some of the, historically, I remember reading about knights in armor. I don't know the exact numbers, but just how heavy the armor was, and how heavy the arms were, extremely heavy. And so, in natural situations, women didn't. You had to be very strong in order to wage war and use these heavy iron weapons in an effective manner, in a generally speaking. Although again, not always. Obviously, we know the stories in which women use these weapons also in the Bible itself. So it's not an absolute rule, but generally speaking, that's the case. Okay, so and that's exactly why here we see in this week's reading that the women were also punished because they were actually used different methods and were also because the method of seduction was being used as a weapon. Women were also seen as dangerous and also needed to be punished, as Moses explains to the soldiers on their return, that women who are of physical maturity also had to be put to the sword. Also very hard to, a little bit bitter and hard for us nowadays to understand, but I think the way we know, the most simple reading is that they were either they actually committed the harms, or that they were a threat, that they were potentially could go about doing the same thing that their nation once did again. And the idea was to eradicate the threat and the harm that they might bring to the children of Israel. Anyways, I'm getting a little bit far afield, but simply wanted to bring out the distinction and also the important point about how a Noahide law can function in a nation also. And just wanted to make the distinction between adjudication of Noahide law and in a war situation or in a situation which involves a pursuer, which may be different, but is also would be included in Noahide law. Okay. So I wanted to point out something actually. Another interesting thing is in today's prayers, we recited a psalm that's directly on point with our subject for today. It's the psalm read on Tuesday. And it says there, a psalm of Asaph, God stands in the divine assembly. In the midst of judges shall he judge. It's talking about judging, right? And it says, until when will you judge lawlessly and favor the presence of the wicked? Selah. Judge the needy and the orphan. Vindicate the poor and impoverished. Rescue the needy and destitute. From the hand of the wicked deliver them. So it's clear from this that the judges are expected to actually be proactive and to seek out cases and to undo injustice and to protect the oppressed. So that's, again, it's an example of how we see that there's a kind of a mingling of functions of police function and judicial function in the biblical model. Because to be proactive would mean, usually the way our courts work is you bring a claim to them, you bring a case to them, and they decide it. They're very they're not proactive. I'm looking for the proper word for that, but they're passive. They sit and wait. Unless you bring something to them, they don't do anything. In fact, according to our Western law, even when it comes to your arguments, the judges don't do anything that they really hardly make argument that the lawyer doesn't suggest. So they're extremely passive. Even though there's all the talk about the active courts and so on and so forth, I understand that. But in reality, in terms of other societies that existed in the past, and evidently biblically, the paradigm of a judge could act in a way in which proactively sought to police and seemed like, in other words, the district attorney and the judge were the one and the same. I don't mean it was the same person, but the same body. in which maybe a judge would say, I want you to investigate. There's something's come to my attention. I want you to investigate such and such, and bring this case before. Or, if for example, if a witness came to the court and said such and such is going on, that the judges would send messengers to investigate and bring the parties to the court and to mete out justice in a particular situation, whatever it might be. So, I mean, yes, in a certain sense, it's similar to today. But it seems like the verses, I think, are certainly, I think, would be requiring a lot more of a liberal system. What I mean by that is, as everybody knows, our system really hardly works without lawyers. The procedure is so complicated, the average person can't navigate it by themselves. They need help. And it seems like that's not what the verses want. They want a person to be able to come and seek a remedy, or how should I say, be able to cry out to the court for assistance without having to put in specific papers and know exactly how and what to say and so on and so forth, but to be able to appear and in simple words of a layman, be able to say this and this happened to me, and that the court should craft it for the person. That's what I believe. I think that's the meaning. I mean, because otherwise you're not going to satisfy these requirements properly of seeking out, judging and vindicating the poor and the impoverished. If you're going to sit in your halls and wait for people to come to you, have enough education to communicate what it is that they need. So clearly that's not the case, that people would come and the judges, based on simple English, simple or not, well, it wasn't English, Aramaic, whatever the language they were speaking, or Hebrew, would just say this and this happened, this and this was done, and I need justice. And the judges would craft it properly and consider, well, according to this, what is the law and what should be applied. And they didn't expect that, again, that's the difference today, that the law courts are very passive. Courts are very passive. So if you want to come to court, you can't just say this happened to me. The judge wants to know, what is your legal claim? And he's going to ask for, common law words and things, and people don't know. But there's no such requirement. And I guess what I'm arguing for is that under the Noahide law, there shouldn't be such a thing either. It's just too complicated. Of course, that would create a situation in which you need a lot more judges than we have today, and it might be very expensive based on our current model of paying judges. And the way obviously society works is that people engage in a certain profession and are doing that all the time. It's not part-time, and they need to get paid. But as you see in the Bible, in the Chumash, that there were thousands of judges. If you may recall, from the reading of Jethro, and in Exodus, there talks about there being judges for every 10,000, for judges for the thousands, judges for the hundreds. That means for every 100 people, there was a judge. There was somebody that could come to arbit a claim. I mean, that's pretty incredible. It doesn't seem like, well, obviously in the desert, they didn't have to pay anybody, I guess, although why not? People maybe wanted compensation. It's also notable to know that Maimonides is very against paying. Well, certainly judges shouldn't be paid by the litigants. If they're paid a salary, it has to come from public coffers, not by the litigants. I think that's kind of obvious, but that's important, that they shouldn't. And there's even an approach maybe they shouldn't be paid at all. It should be voluntary. You shouldn't get paid. Anyhow, so these are some things to consider about this. So, sure.
Briefly?
Please.
Okay. On the Jethro model, if you will, what he's suggesting is that these judges over 1,000, 10,000, hundreds, 50s, what he's suggesting is that the population as a whole should know the law, and we're all intermingled at whatever level the law should be known. And you can have a Supreme Court, if you will, over thousands, and then the lower courts are local. So if a local issue becomes too difficult, and it expands up, which is exactly what he expressed. If it becomes so difficult that it can't be solved at these levels, then it comes to you as a last matter.
Right.
But what he's expressing also is that not only should everyone know the law, but everyone should teach the law. It becomes your responsibility to teach your children, if you will, so that they grow up in a society where they're aware of it. And it's just, it's common. It's like you said, it's the communal common law. Everybody knows it.
Yeah.
And it becomes the norm rather than the exception.
Right.
I think that's what Jethro was trying to point his finger at.
I mean, I think that we certainly see from the biblical story, and also that, everyone was taught, right? I mean, again and again, God speaks to Moses to tell the children of Israel, which clearly the implication is, and it's not really an implication, it's literally a positive statement, that you should teach the masses. Tell them. Everyone, teach them this law. Everyone needs to be taught. And that's also obviously a tremendous difference between the way our society works today and what's envisioned, what took place in the desert under Moses. Now, although in a certain sense, the distinction is that much of, although maybe not all of Noahide law, should be things that should be so clear and taboo that everybody should know it. But again, that's if you live in a society that these things were taught, people learn them at home, and it's just the basic morals of that community, then there's no need to study it in school, per se. But again, this will also depend on the first view or second view. If we're baseline, and so the rules aren't that complex, it's just a question of don't kill, don't steal, no adultery, and so on. And you don't add on the complexities of Talmudic law. So you might argue that there's no need in school necessarily to have advanced studies of this. But even that, you could argue with that. But according to the second approach, in which a Noahide community adopts or needs to adopt much of Jewish oral law and Talmudic law, that would need to be continuing education in school. I mean, I'm just telling you what seems rational. So basically what I'm saying to you, Ross, is that I think the first aspect of education is something that Moses was already doing. But the aspect of judging has a lot to do with disputes and differences of opinion, or the need for a more authoritative opinion. And so you have this idea of, like, for every 50 people, there was a rabbi. It's like the rabbi of a small synagogue, so to speak. Every 50 people, they had someone who they saw as maybe more learned, and who could judge. And then and so on with the greater groups and greater groups. Today, we have, I work in the system, so I can talk a little bit about it, is that, we have very few judges in relation to the number of the population, very, very few. Very different than the situations that were envisioned long ago. I guess part of the reason maybe is that, I think maybe societies that were self-governing had to be more orderly. I don't know. Something to think about. But I mean, obviously, even primitive tribes of small groups had tribunals, had councils, they had the elders made decisions and so on. I don't know in every situation, But I would think in cases of disputes that they would go to the elders and they'd make decisions. That's not even under Noahide law. That's just simple human history. So interestingly enough, we really don't have a lot of that today, meaning that, I mean, certainly in our civil court, I work in the civil courts, and there are thousands and thousands of cases that are heard by judges. That's why it takes so long. It takes such a long time because your case is being heard with, 100 other people every single day. There's another 100 people on the list, right? So something like that, 50 people on the list every day. So, and that's only the people who have lawyers or have, but what about everybody else who has questions? I guess it's also the difference if people were looking at life as something in which, there are rules in it from God that we need to follow and we need to seek counsel, or we want to quote live quote free and really just want to do as we see fit, and we don't want a counsel or an authority telling us what to do. So again, that has to do, as like Ross said, how we're brought up in our home, in our family, in our smaller community, and how we look at the way we should live. And it starts way at the beginning of how a person is brought up in their house, the way their children behave, and everything they start soaking up from their siblings and small children in school, and so on and so forth, the people all around, and messages they get from society around them. So, yeah, I mean, that's really a point we've spoken about many times, about the idea of education and how that's related to this implementing and instituting courts of justice and how they're related. Now, so I just wanted to point out, so there's also another interesting distinction that's brought out in this part of the chapter on pages 252 to 53. And that has to do with the fact that, generally speaking, the first approach in which an individual as a witness can immediately be a police and enforce a law is certainly more applicable in a society where we have a reversion to natural law, where, in other words, there is no government or functioning police force that has been delegated to take over for the individuals to make sure that society, that justice is being done. So when we don't, so in other words, in situations where we don't have, where there's a collapse of government, then you have a situation really, again, that reverts to the people to try to, I guess, to set up one. And it may bring about a situation in which you have vigilante type situations in which individuals will need to take matters into their own hands. I think that's the case of Phineas, right? Case of Pinchas, that's what I see, that paradigm. You see that the leaders are failing to act. For whatever reason, Moses and Aaron don't take action. And there's a bit of pandemonium going on in which things are getting out of hand. You have chaos in which people's masses are starting to rebel. So he takes action immediately to try to stop this, and he's successful. So I think that's a good example of when the direct active justice should be applied. When you shouldn't apply it is when we have proper, legitimate courts and police. In that case, person acting out and taking law into their own hands, even if it means well, could undermine the judicial system, and in that way could actually be violating the law that requires the institution of courts of justice. So goes on to discuss, look at page 255, it explains how, what's the main function of this court? According to the Rambam, it's to warn the people against the infringement of the other 6 laws. So I don't know if that means to punish them and that deterrent acts as a warning, or it means actually also embedded in this is the obligation, as Ross says, is to teach, to make sure to inform the people. That's really seems like a more simple interpretation, because that's the meaning of the word warning. Warning doesn't just mean, it means to warn, but that could also involve a kind of a police force that goes out into the streets and tells them, hey, don't do that. Next time you do that, you'll get arrested, you'll be fined, and so on. That's not permitted. And so that they act, and in that way, teachers, in a certain sense, also act as police by informing the public, young people, of their responsibilities, and they could act as part of the court system. Yeah, I mean, the truth is that I've been very astounded. I may have mentioned this here before, but I don't really talk about it much because it just doesn't come up much, but I'm quite critical of the continued adoption of the old English law and probably Roman law principle that ignorance of the law is not an excuse. It's really not something that makes sense today because we have so much regulation, right? There's just so much, if the law was just don't murder, don't steal, don't commit adultery, don't kidnap, those are things everyone should understand. Everybody should be brought up to. If you don't know, everyone in a normal society knows that. So that makes sense to say you don't need to be taught that, your ignorance is not an excuse. But when you're talking about environmental regulation, when you're talking about, just different, municipal codes and things like that, it's a kind of a stretch to say ignorance is not an excuse. I guess the argument would be, well, you should have asked, what do I have to do? I guess that might be the point, but I think it should still be some type of a factor in terms of limiting a person's exposure to penalty, the fact that they don't know something. That's not common sense. If it's common sense, then yeah, ignorance shouldn't be an excuse. But if it isn't common sense, then, and the same would apply to, it seems like we have this actually earlier, that generally speaking, Noahide law, ignorance is not an excuse. However, we said in nowadays in which people really are ignorant about it because it's been so lost, that ignorance may be an excuse. So it goes on to discuss here about the procedurally, and I think we've also brought this up in the past, about how stringent we should be, how careful we should be in terms of rules of evidence. And the approach seems to be that when a society is in crisis and there's a situation that is chaotic on a certain level, then more lenient, flexible rules of evidence will be sufficient because the society needs to strongly police itself and to punish wrongdoers quickly. In other words, what that basically means from a legal perspective is that at that time, the society accepts the risks of possibly unjustly punishing someone in the interest of creating law and order in the overall society, even though that might occasionally mean someone innocent might get punished. But overall, it's in the interest of the whole society to act in that fashion anyway. As as law and order has been established, and the majority of people are law-abiding, then we can be more strict in terms of the rules of evidence, because then we can weigh against it and say it's more important that we not punish an innocent than, even if that means that there will be guilty parties that go free. And that's the current approach in our system, particularly in criminal law, like in murder and things like that, is the approach is we need to, right, beyond a reasonable doubt, we have to prove guilt beyond a reasonable doubt, which is a high bar, because the judicial interest is that we'd rather have some guilty go free than punish the innocent. And that's the basic policy that's involved there. That applies to these cases also. So, I mean, the truth is, it'd probably be good to go over this inside. But today, does anyone have any questions or comments?